Good day. So, this is episode 17. We will discuss the case of Baclig versus People, a recent case, no? A 2026 En Banc case, GR number 252644, decided last April 8, 2026, and penned by Justice Inting. So, here, Republic Act 10591 was discussed, including chain of custody. So, this case discussed illegal possession of firearms and ammunition. And if you remember in episode 1, our first episode, we discussed the case of Togado versus People, where the court discussed the same thing, chain of custody in RA 10591 cases. And in fact, in this case, the case of Togado was reiterated. So this is the latest case, no, regarding chain of custody kapag firearms cases. So let's see what happened. So the accused here, Tony Baclig II, was charged with illegal possession of firearm and ammunition. So the prosecution presented as witnesses number one, Police Officer Fernandez; number two, Police Officer Langit. The testimony of Police Officer Andrada now was dispensed with after the parties agreed that the purpose of his proposed testimony is to corroborate the affidavit of arrest executed that he executed with Officer Fernandez, and to identify his signature in that document. So on the evening of October 2, 2016, at around 11:15 in the evening or PM, PO3 Fernandez and SPO2 Andrada were performing mobile patrol duty in a PNP service vehicle along the provincial road of Barangay Barangobong. During their patrol, they happened upon a vehicular accident and stopped to assist a motorcycle rider. And later, this motorcycle rider was identified as the accused, no, who had fallen on the eastbound side of the road. While helping the accused, SPO2 Andrada turned on his flashlight, aimed it at the accused, and requested to see his driver's license. As the accused opened his sling bag to retrieve the license, both police officers spotted a handgun inside. PO3 Fernandez promptly confiscated the weapon, which was determined to be a 45 caliber Taurus pistol containing 7 live rounds. So, syempre, pag may nakita silang handgun, unang gagawin nila is to check kung merong permit to carry yung akusado. Pero wala. Because the accused was unable to present a license to possess and carry the firearm, the police officers placed him under arrest. Piotr Fernandez then performed a body search on the accused, recovering an additional magazine containing 6 bullets. At the time of the arrest, the police officers informed the accused of his constitutional rights and the reason for his arrest using the dialect he knew and understood. Then, PO3 Fernandez marked, no, the confiscated items. So, using his initials, PO3 Fernandez marked the seized items as follows: ECF for the 45 caliber Taurus pistol with serial number and NBI 66034, ECF1 and ECF2 for the magazines, ECF3 to ECF15 for the bullets. On cross-examination, PO3 Fernandez explained that he purposely marked the subject firearm on its bottom part to prevent collision and to prove that it is the same firearm he saw and confiscated. He stated that the accused was conscious when they were helping him. He clarified that he saw the subject firearm when the accused opened the zipper of his sling bag after he asked the latter for an identification card. So the regional trial court convicted the accused, and it was affirmed by the Court of Appeals. So the issue here, among others, was whether or not the accused was guilty of illegal possession of firearm and ammunition. So there was a part here in this case where the accused challenged, no, the legality of the seizure of the item subject of the case, on whether it was seized validly or legally without warrant. But the court ruled that the subject firearm and ammunition were validly seized under the Plain View Doctrine. So let's discuss this muna before we go to the main point. The court held that it is undisputed that the police officers were conducting a mobile patrol when they saw the motor vehicle accident involving the accused with his motorcycle. As police officers, they were expected to assist accused and investigate the cause of the accident. When accused opened his sling bag to get his driver's license to identify himself, the police officers noticed the gun inside the sling bag. Undoubtedly, according to the court, the police officers had a prior justification to approach the accused that led to their inadvertent discovery of the subject firearm. When the accused failed to show a valid license to possess and carry the subject firearm, it became readily apparent to the police officers that he had no right to possess it. Verily, the police officers were justified to seize the firearm, which is the primary evidence of the accused violation of RA 10591. However, the court ruled that there was reasonable doubt as to the integrity of the seized items. Okay, let's check the contention raised by the accused first. Now, according to the accused, the joint affidavit of arrest failed to specify the measures undertaken by the police officers to secure the seized firearm and ammunition from the time of their confiscation until they were brought to the Tayug police station. Likewise, according to the accused, the prosecution failed to account on the manner in which the seized items were transported to the crime laboratory, the identity of the receiving personnel, and the procedures observed in their safekeeping following examination. In ruling, the court cited Tugado versus People. The court stressed that RA number 10591 does not contain any provision on the chain of custody and the proper handling of seized firearms and ammunition. The PNP, however, is guided by its own manual, specifically in the handling and preservation of the integrity of the confiscated firearms. The court held that in the instant case, while the seized firearm has a serial number, it still remains undisputed that the seized firearm and ammunition were only marked at the police station and not at the place of arrest without any justifiable reason. Okay? As aptly pointed out by Associate Justice Kagiwa, while the prosecution presented testimonial and documentary evidence to identify the seized firearms, its unexplained failure to immediately mark the item at the place of seizure constitutes a material evidentiary lapse. This omission, according to the court, undermines the assurance that the firearm allegedly confiscated from the accused is the very same item presented in court. The resulting evidentiary gap is crucial, particularly because the prosecution bears the burden of proving beyond reasonable doubt not only the accused's lack of legal authority to possess the firearm, but also the firearm's very existence, both indispensable elements of an offense under RA number 10591. But the court clarified that consistent with their ruling in Tugado, such an evidentiary lapse does not per se by itself, no, does not by itself warrant acquittal. However, where the prosecution's case hinges on the alleged existence and identity of the subject firearm or ammunition, and where the procedural safeguards essential in establishing such identity and integrity are neither observed nor explained, acquittal becomes the inevitable legal consequence. The burden of proving guilt beyond reasonable doubt, whether in prosecutions involving dangerous drugs or firearms and ammunition, rests solely on the strength of the evidence presented by the prosecution. So here, the court adopts the following guidelines, no, proposed by Justice Kagiwa to standardize the treatment of seized firearms in prosecutions under RA 10591. So this is important for those who are in criminal law review and for those who will be taking the 2027 bar exams because this case is already excluded sa 2026 bar exams. So let's see the guidelines. Number one, the firearm or ammunition subject of the charge must be presented in court as the best evidence of its existence and classification. Number two, unlike in drug cases, a detailed chain of custody is not mandatory in firearm cases. However, reasonable measures must be undertaken to preserve the identity and integrity of the seized firearm or ammunition. Number three, similar to drugs, firearms and ammunition are also susceptible to planting. Thus, the following steps must be undertaken by police officers and must be established by the prosecution. Letter A. Where firearms are seized through a search warrant or during a bypass operation, immediate marking of the firearm, conducting of inventory, and taking of photographs at the place of seizure in the presence of witnesses required under the rules of court. So, kailangan yon. Letter B, where firearms are seized after a warrantless arrest, then there should be immediate marking of the firearm, conducting of inventory, and taking of photographs at the place of arrest. Substantial noncompliance without justification may affect the admissibility of the evidence. So take note of these guidelines, okay, laid down by the court in this case of Baclig versus People. Meron pa, number four, procedural irregularities such as delayed marking or incomplete documentation do not automatically result in acquittal. However, if such lapses remain unexplained and if the identity and integrity cannot be otherwise established, reasonable doubt may arise. And if there's reasonable doubt, then it may result to the acquittal of the accused. So the court thus reinforces the doctrinal principle that although firearms cases are not governed by the strict evidentiary standards applicable to dangerous drugs, they must nonetheless conform to the constitutional mandate that guilt be established beyond reasonable doubt. In fine, according to the court, they acquitted Baclig solely on the ground that there is reasonable doubt as to the identity and integrity of the firearm and ammunition arising from the unjustified failure to mark them at the place of seizure. So the accused was acquitted, and the court used the guidelines laid down in this case. Thank you for listening. No, I hope you learned something from this case. This is a new case decided April 2026. So please share this to those who might be interested or who might learn something from this. And please subscribe for those who have not yet subscribed. Kindly subscribe to our videos so that we can avail of some other features of YouTube and upload more videos about criminal law. Thank you very much again for listening, and I'll see you next time.